It's very nice to be invited back. I've got quite a long-standing relationship with Ambitions, and it's nice to be back in this neck of the woods, although it was a very early start from Manchester this morning. So I'm going to talk about the Employment Rights Bill. I think before I do that, I might just tell you a bit about my firm. So it's actually closer to 600 employees now. I'm one of 165 partners, so we're not your average high street law firm. 1978 we started. I haven't been there quite that long, but not far off. And we're a full service commercial law firm, so everything you'd expect a commercial law firm to do, we do. We've offices in Manchester, that's where I'm based, that's our head office. We've got quite a big office now in London, 150 people, and a smaller office in Liverpool. And we're turning over around about 85 million pounds a year. My employment team in Manchester has about 20 people in it. And we provide cradle to grave employment law support. But we do a lot in this sector, the recruitment sector. So we know the ins and outs of recruitment law compliance, gangmasters licensing, conduct regulations, agency workers regulations, and the like. So that's us. I've put some business cards on your table. If you're interested, feel free to call. We're not the type of law firm that starts the clock ticking as soon as you pick the phone up, because we'd like to develop a relationship with you. But if you're interested in taking some advice or having a chat about what you might need from your employment lawyers, then please get in touch. It'd be a pleasure to speak to you. So the bill. Well, we've been waiting for the bill for a long time. Labour had promised that they would introduce some legislation within 100 days of taking office, and they did just that. It landed on about day 98, and it's the Employment Rights Bill. But I thought I'd start really by explaining what you might have heard in the press they were proposing to legislate for that hasn't actually found its way into the bill. So all of these things we were getting really excited about, but they're nowhere to be seen. So if you looked at the bill, you'd be expecting to see some of these, if not all of them, and you'd be desperately disappointed after you'd waded through the 159 pages. It's a fairly complicated piece of draft legislation. The right to disconnect, or the right to switch off, which you'll have heard a lot about in the press. So when your boss calls you at 6:30 in the evening after you've clocked off at 6 and wants you to do a little job for them, you'd be entitled to say, no, I'm not doing that. And you then couldn't be subject to any detriment or prejudice as a result. I don't think it was ever going to be a strict statutory right. I think when you listen to the Labour Party after it got into government, they started to talk more about guidance or policies rather than a strict legal right, because I think they realised that as a strict legal right it just doesn't work. There will be circumstances where you need to speak to your people either before they start their shift or before their normal start time, and after they've clocked off or after their normal finish time. I think we'll still get something on switching off or disconnecting, but I don't think it will be a statutory right. I think it will be a bit of persuasion, so employers and employees working together to try and come to some sort of accommodation about how it works, but recognising that in reality, unless it's urgent, you should be able to switch off after you've left work. The manifesto, the Labour manifesto, also said that they were proposing to legislate around equal pay to make it a little bit easier for people to bring claims and to try and reduce or bridge the gender pay gap. There's nothing in the bill on that either. So what came with the bill was another document. The bill says this is what we're going to legislate on now, and then the document that came with it was a sort of, this is what we're probably going to do, but it'll take a while for us to get there type of document. And equal pay issues and workplace pay gaps were dealt with in that separate document. So we will get something on it, I suspect, but it's just not now. The third one was the really big one that was trumpeted. Angela Rayner said a lot about this in the lead up to the election, as did the Labour Party generally. There are three groups of, I'll call them employed earners. So the law recognises three broad groups. There are employees who have the most statutory protection. They have about 150 statutory rights. So if you're an employee on a contract of employment, you've got the most protection under the law. There's a second category of workers who have some statutory protection. A lot of those statutory protections shared with employees, but not as many. So the biggest difference, or the biggest obvious example I can give you between the two categories is, if you're an employee, you've got the right not to be unfairly dismissed. But if you're a worker and not an employee, you don't have that right. There's another example, which is statutory redundancy pay. If you're an employee, you have an entitlement to a statutory redundancy payment if you're made redundant. If you're a worker, i.e. you're not an employee, you're not entitled to a statutory redundancy payment. There are a whole host of other distinctions between the two. And then you've got the third category, which is legitimately self-employed people, so people who are genuinely in business on their own account. They have almost no statutory protections. So as we stand in this room today, there are those three broad categories. And what the government said they were proposing to do was merge the first two. So we effectively would have a category of worker, which would be current employees and current workers lumped in together. And then you'd have the second category of self-employed people. So we keep that category as it currently is. And the proposal was that if everybody's lumped in together as workers, they should all have the same rights. So that would have meant extending rights like unfair dismissal and statutory redundancy pay to workers, current workers who don't have those protections now. So it will be levelling the playing field, that's the way the government put it, levelling the playing field, giving everybody the same statutory protections. They've shied away from it in the bill, and I think there are possibly two reasons for that. It's in the document that came with the bill, so it's still a clear intention of the government to move to that position, but they're not doing it now because, one, it's very complicated. Legally, it's very complicated. And if you think about it, you're dismantling a very well-established system. And in the recruitment sector, it would be of significant impact because a lot of temporary workers are not employees of the agency, they're workers on contracts for services. So all of a sudden, you would effectively be bringing a group of people in the economy out of one category and putting them into another with a whole host of additional statutory rights. So there's a lot of thought that's going to be needed before we get to that solution. So that, I think, is the first reason why they've shied away from it. They want to consult over it, I think, to make sure that they don't make a hash of it. But the second reason, I think, is it also has a significant impact on tax, because at the moment, workers and employees are broadly taxed in the same way, but there are some differences, and the tax regime is complicated at the best of times. So if you suddenly bring a whole group of people out of one category and put them into another, I think the tax implications are going to be fairly significant as well. So for those two reasons, I think the government have decided to steer away from it. But it's not gone. It's still a stated intention. And I think it will happen. Whether it happens in the next 2 or 3 years or in the next 4 or 5 years, I don't know. But they certainly want to do that. They say it simplifies things, and as well as simplifying things, they also say it levels the playing field. It gives everybody the same rights, and everybody should have the same rights. That's the policy rationale behind it. And the fourth issue that's not in the bill was or is any reference to reviewing parental leave, carers leave, and the transfer of undertakings regulations. Those were 3 areas where the government decided or the Labour Party, before they came into government, decided they wanted to make some changes. They wanted a proper review of all things relating to parental leave. They wanted a proper review of everything relating to carers and carers leave. And they wanted a proper review of the transfer rules under TUPE. Again, all of those are in the separate document that came with the bill. So I suspect we will get something on them, but we're not getting them this time round. And I think when you look at those 4 items on the screen, you'll think to yourself, well, actually, there's quite a lot that's missing. And quite a lot that they promised before they came into office that they were going to do, which we really haven't got a firm timetable on. So that's the starter slide. That's what's not there. And what I'm going to spend the rest of the presentation doing is talking you through what is there. And I'll try and give you my take on it. And the reason it's my take is because there's a heck of a lot of detail, even in 150 odd pages, that's missing. So I can give you broad principles, but I suspect some of the more detailed questions you'll have, I'll just have to hold my hands up and say, I'm sorry, I can't answer them. I'll give you my best guess, but that's really all that it is. And the point was made at the start that we don't really have to worry about this now. So you might say, well, why am I here? Well, you're here because you're getting nice pastries and coffees and teas, and you get to look at me for an hour, which is, that's reason enough. But there isn't anything that's going to happen on these proposals until the end of 2025. And even then, not all of this is going to come into force then. We've already had an indication from the government that some of the more difficult bits and pieces might be delayed until 2026. So we've got some time to think about it, 12 months or so. And when we go through some of the provisions, I think you'll want to start thinking about them now, because you'll recognise that if you don't start to grapple with some of these topics, we'll get to next year before you can blink, and then it will be difficult for you. Okay. So the first topic I want to talk about is exploitative 0 hours contracts. I put exploitative in inverted commas because that's a new insertion. If you look back to the Labour Party's position even 12 months ago, they were adamant that they were going to abolish all forms of 0 hours contracts. Then someone had a quiet word in their shell-like and said, you know what, I don't think that's such a good idea, because it will reduce flexibility in the workplace. And if you're a party that's championing flexibility, in particular workplace flexibility, you might want to think very carefully about that policy. Is it right that you get rid of all 0 hours contracts? I think it was interesting because I've seen some research on this issue, and I don't suppose it'll take anybody in the room by particular surprise. There are lots of people on 0 hours contracts who positively want to be on them. This is not a question of 0 hours contracts being forced on a group of people that don't want them. I accept there will be some instances where that happens, but there are lots of people on 0 hours contracts who want to be on them. And the best example of a 0 hours contract, although we're not entirely sure how the legislation will deal with these, the best example is an agency workers contract. If you think about it, that's a 0 hours contract in its purest form. There's no obligation on the worker to take the job offer that the agency sends to them. And there's absolutely no obligation on the agency to send them any jobs at all. It'll depend on whether the agency's got any jobs from its clients to fill. And if it has, it then looks around, makes appropriate offers, and the workers can either say yes or no. That's the purest form of a 0 hours contract. So if that was going to be banned, I suspect there'd be lots of people in this room who'd be rather concerned, because it would cause all sorts of logistical difficulties. Certainly the agencies will be very concerned about that, because they'd have to change their whole model, and it will become very, very difficult. So the point I'm trying to make is, having looked at it and examined it and considered it in a bit more detail, the view was taken that getting rid of 0 hours contracts completely wouldn't be the right thing to do. But Labour doesn't like 0 hours contracts, so I think it felt it had to do something about them. So it changed its policy position and said, we're going to ban exploitative zero-hours contracts. In reality, what's in the bill is not a ban. It's simply more regulation around certain types of zero-hours contracts. So there's nothing that says exploitative zero-hours contracts can't exist. There are provisions which we'll come on to that regulate zero-hours contracts in a way that make them fairer, depending on your political persuasion, make them fairer for the worker. Most of these provisions are worker-centric rather than employer-centric. So the provisions that are in the bill around zero-hours contracts are reasonably straightforward, and the concern has always been that workers who are on zero-hours contracts can be put in a difficult position, normally by the employer. So what the bill says is that if you're on a zero-hours contract, and indeed if you're on a minimum hours contract, and if you think about that, that's got to be right, because to get out of the provisions I'm going to come on to in a second, you could simply say to a worker, I'll guarantee you 1 hour's work a year. So that's not a zero-hours contract, so I don't have to worry about any of these provisions. I'm off the hook. So the government have got wise to that, and they've said zero-hours contracts, contracts that offer you no guarantee of any hours at all, and minimum hours contracts, so contracts that say over a period of time we will give you a minimum of X hours, so maybe say per month, 5 hours a month, or an annualised contract, 300 hours a year, whatever it turns out to be. A minimum hours contract is treated in the same way as a zero-hours contract. The bill says that if you're on either of those two contracts, your employer is required to offer you a guaranteed hours contract. Now, a guaranteed hours contract is pretty much what it says on the tin. It's a contract that gives you an absolute guarantee of a certain number of hours, but it's not just a certain number of hours that you pluck from thin air. It's not a number that you just decide on randomly. The bill brings in a process by which you look at the hours that the individuals worked over a reference period. We think that reference period is going to be 12 weeks. So look at what they've worked over the previous 12 weeks, average it out, and that will give you what the guaranteed contract should look like. The guaranteed hours contract should be for the number of hours that have been worked on average over that reference period. So that's the first big change. And if you think about it, there are going to be lots of people that don't want that. But the right is not to a guaranteed hours contract, it's the right to be offered one. No obligation on you to accept it, but you're going to have to be offered one if you're in either of those two categories. So that's the first change. The second change really is all about logistics. So circumstances where a zero-hours contract worker receives a phone call at 6 o'clock in the morning to say, we've got a shift for you, but it starts at 10 minutes past 6. Can you make sure you get in? Otherwise the shift's gone. Sorry, I'm exaggerated. I don't think it'd be 10 minutes, but who knows? It might be 10 minutes. And the worker says, oh, well, I'm still in my pajamas. I've got a bit of a problem with that, but I'll try and get there. And they get there for 10 past 6. What the government says is that's exploiting zero-hours workers, because people on normal contracts know they've got a fixed start time, usually, and a fixed end time. Zero-hours contracts don't have, or zero-hours contract workers don't have that guarantee. They don't have that certainty. So the law's going to change to make the employer give reasonable notice of the start of a shift. So the question is, what's reasonable notice? The answer is, I haven't got the foggiest idea. How's that? It was worth coming just for that, wasn't it? Yeah, I don't know what reasonable notice will be. We don't know whether reasonable notice will be prescribed in a statutory instrument or whether it will just be left to the courts and tribunals to decide. It probably will be left to the courts and tribunals to decide, because what's reasonable in one sector may be wholly unreasonable in another. But the law will change to say, if you want a 0 hours contract or a minimum hours contract, you need to be given reasonable notice of the start of a shift. Okay. The third change under this heading, again, is to do with logistics. So to do with a situation where the worker gets the phone call, is asked to go into work for the start of a shift, gets there, having taken 6 trains, 4 buses, and spent an absolute fortune on emergency childcare, only to find that when they get there, the supervisor says, "Oh, I'm sorry, that shift's gone. You'll have to go home, we've got nothing to offer you." That is going to be unlawful under the new regulations. If a shift is going to be cancelled or changed, the obligation is on the employer, and we'll talk about who that is in a minute. The obligation is on the employer to make sure that reasonable notice of that cancellation or reasonable notice of that change is given. The question is repeated, what's reasonable notice? I haven't got the foggiest idea, but it probably will be something for the courts and tribunals to determine, because again, each sector is different. So what's reasonable in one industry sector may be totally unreasonable in another. So those are the 3 strands of the new law relating to 0 hours contracts. And you can see where the focus is. The focus is on exploitation. I think that's an overused word, but the policy thrust is very simple. It's about recognising that a lot of 0 hours contracts, a lot of 0 hours contract workers have historically been badly done to. And this is a shift. This is moving the balance very much in favour of the worker, so that that sort of treatment hopefully doesn't happen. Now, if any of these new provisions are breached, well, there's got to be a sanction, hasn't there? You know, the worker just doesn't sit there and lick his or her wounds. They've got to be able to do something about it. And the good news for me as an employment lawyer is that they'll be able to bring that matter before an employment tribunal. I'll be able to retire a few years earlier than I thought I was going to be able to. And they'll be able to recover any financial losses arising as a result of the breach. Any financial losses. What we think is that that amount will be capped. And you can think of, you know, the example I gave to you earlier about someone who's phoned up and has to organise very costly emergency childcare. Well, that would be a loss, wouldn't it, if they turned up for the shift only to find the shift's been withdrawn or someone else has started instead of them. That emergency childcare cost will probably be any financial loss sustained as a result of the breach of that provision if reasonable notice wasn't given. So you can see there's going to be a bit of a field day here as to what loss was caused by what breach or what loss wasn't caused by what breach. But we think there'll be a cap. But again, we don't know what the cap is going to be. So it won't be unlimited losses that can be claimed for. It probably will be capped, a little bit like unfair dismissal compensation is capped at the moment. We don't know what the cap looks like. So a new landscape really around 0 hours contracts. And the reason I wanted to put this slide up is because some of you might be scratching your head thinking, well, hold on a second, does that just operate in the context of employment contracts, or does it operate in the context of contracts for services, so worker contracts in this sector in particular? If you're using temps, how do these new laws, or how will these new laws affect us? So I've got to give the government some credit here. I think they've realised that that's quite a complicated topic, and they haven't quite worked out what they want to do about it. So they have issued a consultation document. It came out, I think, on the 24th or the 27th of October, and you can read it. You know, if you're having trouble sleeping, it's not a bad idea. I think 2 things arise from it. First of all, you'll notice the deadline for submissions, for responses to the questions that are raised. That's only the 2nd of December. So I think they're quite keen to move on with this. So they've put a consultation document out. They're giving you just over a month and a week or so to feed in your responses. So that's the first point. And the second point, which jumps off the page when you read the consultation document, is how little the government really understands the agency sector. You know, there are some terribly obtuse and naive comments and statements made in that document. And when I first read it, you know, my jaw was moving gradually further towards the floor as I turned each page. It's a very interesting read, let me put it that way. But there are some pretty serious questions that it asks, and I think if you're either providing temporary workers as an agency or you're using temporary workers as a client, I think you should read it. And I certainly think you should think about responding. There are lots of things that it covers, but having analysed it, there are two options that are being considered. Both of them are at completely opposite ends of the spectrum. The first one, option number one, is giving the responsibility for all the rules I've just spoken about, including offering a guaranteed hours contract, giving the responsibility for that to the agency. Now you'll say, well, yeah, well, that makes perfect sense, Paul, doesn't it? Because the agency is the organisation that employs the worker. That's where the contract sits. So it probably should be the agency that has the obligation to offer a guaranteed hours contract. And I can see that. I think the difficulty is when you read the consultation document, it doesn't contemplate the use of umbrella companies. So umbrella companies slot into that supply chain at the bottom end. The umbrella company employs the worker. The umbrella company then supplies, pursuant to a contract, to the agency, and the agency then supplies the client. There's no real consideration of umbrella company employment in this option one. But in general terms, it makes sense. Everything we've spoken about, it seems to me, suggests the responsibility should lie with the employer, which is the agency, in an agency supply. But they are considering a second option. And for those clients in the room, you won't like this one. Should the responsibility for everything we've talked about, including offering a guaranteed hours contract, should that rest with the hirer, the client? Well, that's a bit strange, isn't it? Because the hirer currently doesn't have a direct contractual relationship with the agency worker. So does this mean that the government are considering requiring the hirer to make an employment offer to the worker, so they no longer work for the agency? Right. So for those of you who've had the misfortune of being on the receiving end of an employment tribunal for unfair dismissal, you'll know that your employee can only bring a claim if they've got 2 years service. That's the current qualifying period. There are some exemptions to that, but they're very limited. So there are some unfair dismissal claims you can bring without 2 years service. But 2 years continuous service is also a qualification requirement for a statutory redundancy payment as well. You've got to have 2 years service before you can claim a statutory redundancy payment if you're made redundant. What the government's proposing is the removal of that qualifying period. So as soon as your employee crosses the threshold on day one, they have unfair dismissal protection. You don't have to wait 2 years, or they don't have to wait 2 years before bringing the claim. Now that on its own is very radical, isn't it? It's very radical. I've never seen, in all the 30 years that I've been practicing, I've never seen 0 continuous service as a requirement for unfair dismissal. Yes, it did drop to 12 months at one point a number of years ago. So you only had to work for 12 months before you got the right to bring a claim. It then jumped up to 2 years, and it's been at 2 years really for as long as I can remember. It's going to be swept away. So everybody will be able to bring a claim as soon as they start. So quite radical. And again, I think someone's had a little word in Labour shell-like and said, have you really, really thought this through? Is it actually going to work like that? Or are you going to be loading a whole load of administrative and financial burdens on employers by allowing people to bring tribunal claims the minute they walk over the threshold? So what they've come up with, because I think that's registered with them, what they've come up with is this statutory probationary period concept. And frankly, when you read it in the bill, I mean, I've read it probably 6 or 7 times. I've even had a couple of glasses of wine in between readings, and it's totally incomprehensible, and it still requires more detail. So they've said, this is the framework, which is very complicated, and we're going to put a statutory instrument before Parliament which will give the detail as to how this is going to work. So all I can give you here is the broad framework. But it's important to make the point that the introduction of this new statutory probationary period is not imposing a qualification period for these statutory rights. That's not what it's doing. Because when I explain it, you might think it's a qualification period by the back door, but it isn't. The qualification period will be nil. That's the starting point, so bear that in mind. But the statutory probationary period, which we think will be 9 months, there was a discussion around it being 6 months, but we think now it's going to move to 9 months, but we don't know for certain. What that will mean is that you can engage somebody, and in the first 9 months, whilst they do have statutory protection for things like unfair dismissal, there'll be a new regime brought in which will make it much easier for you to terminate their contracts without liability. So they'll still have 0 continuous service as a requirement to bring a claim, but for the probationary period, there'll be some sort of framework which allows you to do a bit more than you might otherwise have been able to do before without incurring liability. So that's why I say you need to focus on the fact that the qualifying period is disappearing, because it is. Don't think about the statutory probationary period as a sort of qualifying period by the back door, because it isn't. They'll have the right to bring the claim. It's just that you'll have a bit more flexibility about how and what you do with them in that 9-month period. But I can't give you any more than that. That's really all we've got. And, you know, this could be very complicated. If you think back to the good old days of when there was a statutory code on disciplinary and grievance procedures, not the ACAS code, a statutory code, where you had to follow every single letter and line of the code, otherwise you'd be liable in tribunal, that was desperately complicated. I mean, that made dismissing people, you could do it, but it made it very, very complicated. You were hamstrung by very, very detailed statutory processes. And thank goodness all of that was eventually swept away and replaced by it is a statutory code, the ACAS code, but the tribunals have got a little bit more flexibility around compliance or non-compliance with it. I worry that this new statutory probationary period might end up being as complicated as all of that. So, it's good news for the lawyers. We like complicated things. It keeps us in pork scratchings at the weekend, but it will be really, really difficult for you if you're employing people. So the takeaway from this slide, the qualifying period is going, and the statutory probationary period might give you a bit of flexibility, a bit of leeway, but it's not a qualifying period by the back door. Okay. Flexible working. This is another retreat. I mean, this bill is full of retreats from previously stated Labour positions. Flexible working was going to be the default position for all employees, Labour said. Flexible working will be the default position. So when we got the bill, we thought, well, there's going to be a load in here about flexible working. It's going to change the landscape. And we read it, and actually it doesn't do very much at all. In fact, it hardly changes the current regime. So you'll be well aware currently that your employees can make flexible working requests. You'll be very well aware of the fact that you've got to go through a process to consider that flexible working request. And you'll also be very mindful of the fact that you can only reject a flexible working request if you satisfy one of 8 statutory criteria. And that's the current regime. It's quite easy to slot into one of the 8 statutory criteria, if I'm honest. So if you really do want to reject a flexible working request, you know, without being silly about it, you pretty much can relatively easily. So we thought if flexible working was going to be the default, maybe we'd see some changes to that process. Maybe we'd see a reduction in the number of statutory grounds that you could rely on. Well, no, we don't get that. It's the same 8 statutory grounds. So what has changed? Well, actually not a lot. All that's changed is you've got to be a little bit clearer about your reasons. Wow, there we have it. So that's the radical change to flexible working. It's exactly the same scheme that we've got now, with the same number of statutory reasons to reject a request, and all you'll have to do is use clearer language when you explain it to your worker. I think that's really radical. And they're not even changing the penalty. Currently, if you fall foul of the flexible working rules, you can be ordered by a tribunal to pay up to 8 weeks' pay to that aggrieved worker that's made the flexible working request and has had it rejected. You might have thought that if flexible working was going to be the default position, that the penalty would have increased. No, it's still 8 weeks. I mean, this is a massive damp squib as far as I'm concerned. It's a huge retreat from where the government or where the Labour Party said they wanted to get to. And there's no suggestion in the document that comes with the bill that they're going to do any more on this. So this might be all we get in the first 5 years. It might be all we get. So there you have it. Wow. How exciting. Statutory sick pay. This is a big change. I know it's only 3 points on the slide, but it's actually quite a big change. And again, it's driven by a sort of Labour Party view, which I think was fueled by what happened in COVID. Lots of people, of course, didn't work in COVID. They either had COVID or they had other illnesses arising out of COVID. And there was a big demand for statutory sick pay, especially if they weren't furloughed. And statutory sick pay is not a lot of money when you consider the average salary these days is north of £400 a week. I think statutory sick pay, I don't know the exact number, it's in the low £100. So that's all you get. And by the way, I should make the point that none of what I'm about to say affects anybody who pays contractual sick pay. I'm only talking here about statutory sick pay. If you pay contractual sick pay, you'll carry on as is. All that will change for you is if your contractual sick pay is deemed to include any statutory sick pay entitlement, then this will affect you because it will determine how much of that contractual sick pay is deemed to be statutory sick pay. So if you operate it now, you'll know that people don't get statutory sick pay the minute they go off sick. They've got to be ill for 3 days. And then they can claim statutory sick pay on the 4th day. Those 3 days are known as waiting days. Labour doesn't like waiting days. Labour thinks that you should get statutory sick pay the minute you say you're ill and can't go into work. So they're abolishing the 3 waiting days. So you'll get statutory sick pay as soon as you ring your employer and say, I'm not very well. Currently, you only get statutory sick pay if you earn more than a lower earnings threshold. Yep. If you earn less than that, you don't get it. If you get more than that, you do. They're going to remove the minimum earnings threshold. So there's 2 things there, aren't there, financially? One, you're going to have to pay it earlier, so there's more cost involved. Secondly, more people are going to get it, because those who earn less than the lower earnings limit will now be brought into the scheme and they'll have to be paid it. So those 2 provisions are already adding cost to SSP. And the 3rd change adds more cost, because instead of SSP being a flat rate, which is what it is now, the government are suggesting it will be a percentage of that person's normal pay. But we don't know what that percentage is. I mean, heaven forbid it's 90%. I don't even know what an appropriate percentage would be. At least you know where you are with a flat rate. You might disagree that it's at the right level, but you know where you are with a flat rate. With a percentage, not sure how you're going to necessarily be able to plan very easily what your exposure might be to statutory sick pay. So 3 points on a relatively small slide. I think there's a lot of cost there that will have to be factored in, and of course, you know, I'm not a financial expert, but the recent budget, you've got a lot of additional costs there too. So we've got this to worry about as well. There's a little bit of me, the Machiavellian bit of me, thinks that the reason all of this is delayed until 2025 is because they knew that in this budget they were going to be increasing the burden for employers in a different way. So rather than having all of that plus this, which I suspect would put lots of people out of business, they've decided to do it in this staged fashion. But I think that is a really big potential, well, not a potential, an actual change. So we should know what the percentage rate is going to be. And sorry, I should say about the percentage rate, we're not sure that the percentage will apply across the board. There might be a point at which, if your salary doesn't get above that number, you get that number. And then it's a sliding scale beyond that number. But again, we're just hearing things. There's no obvious evidence of any of that. Maternity rights. This, I think, is another quite radical alteration to the current position. Pregnant women and women returning from work after pregnancy are already in a special category. There are already some statutory protections for pregnant women and women returning from maternity leave. This proposal extends that protection, and I think it's very, very significant. So the proposal is that if a woman is pregnant, has the child, and then comes back to work, she is guaranteed a job for 6 months. So she can be the worst employee in the world. Yeah? But you can't do anything with her for 6 months after she returns. So it's effectively, in all circumstances, a guarantee that your employment will continue for at least 6 months after you return from childbirth. So I'll just let that one sit. Yeah. It's a big change. It's a big change. And, you know, there'll be different views as to whether that's right or wrong, but it's certainly a very clear indication as to the direction of travel. The direction of travel is much more family-friendly stuff, which links in with this concept of flexibility. More flexible working arrangements, a recognition that family obligations can give rise to problems, logistical problems, both for the women and for the men. And this is quite a shift. Sexual harassment. I used to tell a joke about this in years gone by, but I was cancelled. So I won't tell the joke I used to tell because it's just not appropriate. But there has been a big change to the law relating to sexual harassment. In October, there was an Act of Parliament brought into force that raised the bar for employers. So if sexual harassment, prior to the October change, if sexual harassment happened in the workplace, so if you, the employer, had an employee who sexually harassed another employee, you could be sued as the employer because it's discrimination. It's a form of discrimination on the grounds of sex or gender. You could be sued for that, and indeed as could the employee who was guilty of the harassment. Pretty straightforward. We've lived with that regime for a long, long time, and quite right too. But two changes happened in October. First of all, there was a new obligation placed on employers to take reasonable steps, ignore the word all, I'll come back to that, to take reasonable steps to prevent sexual harassment. Now that does raise the bar. That obligation didn't exist before October. There was no specific statutory obligation on an employer to take reasonable steps to prevent harassment. They will be liable if the harassment happened, but there wouldn't be any obligation to prevent it in the first place. Now there is an obligation to prevent it. But there's also an obligation now to try and prevent sexual harassment that might happen or might be done by a third party. So let's say you're in your factory and you get some scaffolders from a third party scaffolding company who come in and put their scaffolding up, and in the meantime decide to sexually harass some of your female employees. You're now on the hook for that harassment. You weren't previously because they weren't your employees. You would only be, as the employer, liable for them if they were your employees. But the law's now changed to make it clear that if someone comes in from outside and sexually harasses a member of your staff, you as the employer are liable for that. And if you didn't take reasonable steps to prevent it, so let's say someone tipped you the wink that this firm of scaffolders were well known for their sexual harassment, but you didn't do a risk assessment, you've fallen short of your obligation to prevent the sexual harassment of your employees. So the burden or the bar has been raised and the liability exposure has been extended. That's already in place as from, I think it was the 26th of October or thereabouts. But this government's not satisfied with those changes. This bill inserts a word that was originally in the previous bill that came into force as an act in October, but was dropped because the Conservatives thought it raised the bar too high, and that's the word in red. So under this bill, the obligation to take reasonable steps will change. It will be an obligation to take all reasonable steps. So you won't just be able to get away with, oh, I took reasonable steps. These are the steps I took, steps 1, 2, and 3. Under the current regime, if they were reasonable, that's fine, you wouldn't be liable. But if the judge thinks there was a 4th step that you should have taken, and you didn't take it, you won't have taken all reasonable steps, and therefore you'll be liable. And that is a huge change, even to the current position. The current position is to take reasonable steps. The new position will be to take all reasonable steps. Now, bear in mind, you don't really have an enormous amount of control over what your employees do in the workplace. You really don't. So there are some practical things you're going to need to think about. First of all, do your employees know that the law's changed? I think that's absolutely crucial. They need to know what the new obligations are, and they need to know what the new obligations are going to be. Have you got proper policies and procedures in place about sexual harassment in the workplace? If not, you need to think very carefully about having some policies and procedures. But don't fall for the old trick, which is, well, we'll do some policies and procedures and we'll put them on the intranet and we'll just leave them there. Because if no one reads them, or if no one's trained about them, what they mean and how to handle them in practice, you might as well not bother having them in the first place. If you're going to have policies and procedures around all of this, you've got to make sure that everybody's aware of them, understands them, and knows what to do in instances of alleged sexual harassment. So you're going to need to think about training people. You're also going to need to think very carefully about undertaking risk assessments. So let's go back to the scaffolding example. If you know those scaffolders are naughty boys, and they're going to come into your premises and they're going to sexually harass your female employees, you might want to do a risk assessment first. Because if the evidence in the tribunal is, well, my employer knew what these guys were like, but he still let them in, and they were doing all these awful things to us, the judge will say, well, where was your risk assessment? Why did you let that happen? If you knew that they were like this, why didn't you properly assess the risk? So there's a lot to think about here. We're giving lots of training to people around all of this, and we're getting lots of inquiries from people who are just coming to terms with the fact that the law's changed and wondering what it might mean. So if you weren't aware of that, please make yourself aware of it pretty quickly and keep an eye on the change, because the burden, the bar is going to be lifted up another few inches. Yeah. The downside, if you get it wrong, so if you've not done all of these things that you should do to prevent sexual harassment in the workplace, and someone sues you, they'll be able to get an uplift in their compensation of up to 25%. So if you were going to have to pay £10,000 in compensation for injury to feelings, you're immediately facing 12 and a half. Yeah.
So, talking about the third party, so if you deem to your workplace and last year or all along you should have done what you should have done to protect them. If you've got agency workers on your site, can they bring a claim against you as the hire with their harassment?
They could already do that. So an agency worker who is sexually harassed either by another agency worker on site or by a member of the client's staff on site can already bring a claim. I think if you use agency workers, then I think your policy needs to ensure that it covers both your own people and the agency workers. But third parties, agency workers will be third parties for this provision as well. So they're not employed by you. They will come in from the employer, from the agency employer. They're a third party. If they then harass your staff, yeah, you could be liable for that harassment by the third party. Yeah. So it's a big change. I'm conscious I'm running out of time, so I'll speed up a bit. Oh, that's the last slide. That was good, wasn't it? Yeah, so these are just, this is like a sweep up slide. One that's not on here, which I thought I would mention, you'll have heard a lot in the news about fire and rehire. Do you remember in the news, P&O Ferries a few years ago decided they wanted to change all of their workers' terms and conditions. So they offered them new terms and conditions which were much less beneficial than their original terms and conditions and said, if you don't accept these, we're going to sack you. They didn't accept them, so they were all sacked. They were re-offered the terms. Some decided to take the terms because a job was better than no job. But P&O then backfilled with a lot of cheap labour from overseas. And it didn't go down very well, you might remember. A lot of things said in Parliament about it. Labour particularly didn't like it. They thought it was pretty disgraceful. It's been a feature of employment law for as long as I can remember. It's a basic contractual principle. What you're effectively saying is there are business requirements that necessitate a change in your terms. You're either paid too much or we just can't sustain this cost, this overhead. We're restructuring. You're going to have to take less money, otherwise the business is in difficulties. So the fire and rehire concept has been around for a long, long time, but I think as a consequence of P&O where it hit the headlines, it was a particularly egregious example. Labour latched onto it and said, well, we're going to do something about it. Well, they said they were going to ban fire and rehire. They said they were going to ban quite a few things. This is another thing that they're not actually banning. What they're going to say is that if you do fire and rehire, you'll have the right to bring an unfair dismissal claim, and it will be an automatically unfair dismissal claim. But there will be certain exceptional circumstances where you can't bring that claim, and they are largely to do with the solvency of the employer. So if the employer can show that if they hadn't done this, they were either going to go into liquidation or administration, or they're going to be wound up, some insolvency situation which threatens the viability of the ongoing business, that would give them a defence to a fire and rehire automatic unfair dismissal claim. So they're clearly not banning fire and rehire. What they're saying is in the vast majority of cases, it will be unlawful. But if you as the employer have an exceptional circumstance defence, you're effectively off the hook. What the government said they were going to do is legislate around reducing the gender pay gap and also putting in place a strategy to deal with women going through the menopause. Been a lot of that in the press over the last 2 or 3 years. And again, nothing immediate, but there will be some legislation on both of those two things. There's a very technical change that the bill will effect around collective redundancy consultation. And again, I haven't really got time to go into it in great detail, but anybody familiar with the Woolworths case, when Woolworths existed, used to love pick and mixes. from Woolworths. They were a lot cheaper than the cinema pick and mixes, I seem to remember. Anyway, Woolworths doesn't exist anymore, but Woolworths got embroiled in a collective consultation problem, a case that went all the way to Europe, about whether when you're determining if 20 or more people are at risk of redundancy, you just look at each Woolworths shop, or whether you look at the whole of Woolworths across the entire nation. So we didn't like what the European court said, it didn't suit us, and Labour still don't like it. So they're changing the law in this bill to make it abundantly clear that all you've got to do is look at the whole organisation and not the individual units. Because obviously if you've got an individual unit with 20 people in it, your obligation to collectively consult arises. Yeah. And then the third point I wanted to make is the written statement of particulars of employment. Every employee is entitled to a written statement. It's set out in Section 1 of the Employment Rights Act, Section 1 and Section 2, what's got to be in it. So it's a list of requirements. It's normally covered by the contract of employment. So if you issue a contract of employment, that will probably be compliant with Section 1. What the government are legislating for here is a requirement that in your written statement of particulars that you issue to everybody, you have to put a sentence in to remind them that they are entitled to join a trade union. Yeah, I don't think you can get that from a Conservative government. But there'll be a line that you have to put in your contract that says, just a little reminder, if you'd forgotten, you have the right to join a trade union. And just whilst we're on trade unions, it's not on the slide, but I'll mention it. There's a big part of the 150 odd pages in this bill that relates to trade unions and trade union law. Again, in the press over the last few years, you'll have seen the Labour Party being very critical of how difficult it is for trade unions to call lawful industrial action. Lots of very detailed minutiae, lots of requirements to satisfy before that industrial action is lawful. And, you know, we get instructed by employers to go off to court and get injunctions against trade unions who want to call industrial action when they've not dotted all the I's and crossed all the T's. The government want to pull back. They really want to get back to the position before Margaret Thatcher became Prime Minister, when it was very easy for industrial action, lawful industrial action, to be called. Secondary picketing was very, very prevalent back then. Right back to that, but they're certainly promising in this bill to make it a lot easier for people to take industrial action and for unions not to be on the hook if they've not dotted all of the I's and crossed all the T's. So there you have it, 159 pages in an hour. Thank you very much for your attention. I'm happy to take some questions. I'll be around for a bit longer when we finish, but it's been a pleasure. Thank you.